Welcome, everybody. We'll get started in just a few minutes. Welcome, everyone.
Hi.
Wow, Tommy, you're able to join us for a meeting that has Attorney Bobrowski. This is a rare occurrence. In fact, a first occurrence.
Yes, it is.
I suppose it makes me want to play like Bruce Springsteen or something.
Okay.
Okay, and since we have a quorum, do we have a volunteer to take minutes for this evening?
I can do it.
Thank you, Catherine. You're nominated, you're accepted, done. Okay. Catherine will again take quality minutes. Welcome, Tim. So call the meeting in order at 7:01 p.m. We have 6 members in attendance, so we have a quorum present. Attorney Bobrowski will be joining us momentarily. He is in the process of setting up at a middle school, or I think it's an elementary school out in Berkeley. That's where he's going to be joining us from. So as we get started this evening, again, Attorney Bobrowski will be joining us as soon as he is able to get connectivity. He will join us for as long as he can. He does have a possible conflict which may cut into our time this evening, that he is helping present a bylaw article in Berkeley where they're doing a recodification, and there's some components there that he's been asked to speak on in one of the later articles in their town meeting. First, they have to get through a budget and a bunch of other things, so he should have at least an hour with us from the time that he's able to join. Shouldn't be too much of a problem, but did want to present that. He and I had a brief discussion earlier, so none of this will be much of a surprise. So as he's getting set up, we will get on with the agenda itself. Anyone from the public who wishes to speak, that would be Tom or Theo at this point in the public engagement session, you are welcome to do so. Otherwise, seeing none, we will go on to the minutes. So the minutes from May 1st, taken by Catherine. Thank you very much. Did a good job on those minutes. Were distributed. As we get ready to get started, do we have a motion to accept the minutes as presented?
So moved.
From Joe, do we have a second?
Second.
Seconded by Kevin. Okay, excellent. So with that, we've got discussion minutes from May 1st. They contain the requisite items of the members present or members absent when the meeting was called to order, that everything was by roll call, that it was taken by Zoom, and has summaries of the discussion items. Any comments, recommendations, proposed changes? I made some minor Scrivener's corrections from the original submission.
No, looks good.
Okay, with that, we've got a motion on the floor to approve the minutes, and it's been seconded. Seeing no discussion, all in favor, we'll do this by roll call in the order in which you appear on my screen. So Eric, you appear first on my screen. In favor, Eric? Catherine?
Yes.
Kevin?
Yes.
Joseph?
Yes.
Tim?
Yes.
And I vote yes, so we have unanimous approval. Thank you, Catherine. Good job on the minutes, and you did such a fantastic job. You get to do, and you signed up to do it again. Thank you very much. Do appreciate it. I'll go ahead and post a note to the minutes when they were approved and send them on to the town clerk and to the administrator's office so that they can get posted to the website. That's where all the information from this committee is typically posted. So with that brings us over to the main item for this evening, which is the reviewing of the bylaws, the zoning land use table, and the definitions. These were presented by Attorney Bobrowski. I believe that a copy of them was sent along to everyone. If anyone does not have access to them, please let me know. In addition, I can certainly share a screen to present them, but so that people who may not have seen them were able to go through those as well. So Attorney Bobrowski will be with us for as long as he can. My understanding is that it should be realistically for at least an hour until he is called into session over in the small town of Berkeley, where I believe you have a meeting. You've got a discussion of an item on town warrant. So
Yes,
with
this is town meeting time in Berkeley tonight, and the finished product is before the voters. So they're just calling their meeting to order. I'm sitting in some spare, it's like a teacher's lounge area or something with a hookup to the internet. So thank you, Mr. Chairman. I think you probably could share screen. That probably will make it easier for everybody.
Certainly. What would you like to put up first?
No, just put up the use table
Perfect.
with the A residential uses page, and we'll take it a page at a time.
I just get it to so that it's more legible. There we
Great. So let me tell everybody what I did. I took your existing use table, which is pretty comprehensive, but very unorganized in that it jumps around all over the place. And I tried to isolate, for example, under A, these residential uses, single family detached, two family. We're both together, but these conversion things were 2 pages down in the old use table. You know, typically what this does is go single to multifamily. You've got some conversions to 2 family uses and 3 family uses that fill in that gap. Mid-rise apartments. Open space development is an alternative form of residential development. So is mixed use, so is creative development. I didn't change those. I'm just holding a spot for those. When I holding a number for those, when I put the entire document together, I'll know exactly what section they should be. So there's nothing really unusual about your choices here in the first 9 items. Lodging or rooming house is only allowed in 2 districts by Board of Appeals special permit. And that's a little strange at this late date, 2023. If that still works and it isn't presenting any kind of a fire danger, then I think that's okay. The one change I did make for discussion purposes is to go to senior housing facility instead of assisted living facility. Senior housing facility would be a number of different alternatives for seniors, including independent living, assisted living, memory units for those who are suffering from dementia, long-term care facilities, which is the new name for nursing homes, and any combination of the above, which would be a congregate care facility. In my neck of the woods, Carlton Willard in Bedford is probably the most renowned congregate care facility. Those of you who drive Route 2 will know that there's a huge facility at the corner where you make the sweeping left-hand turn going westbound at the old mobile station. That's in Lincoln. Those are examples of congregate care facilities. I should set this up by saying, furthermore, that Y is allowed, no is obvious, BA is Board of Appeals of Special Permit Granting Authority, PB is Planning Board of Special Permit Granting Authority, and on a couple of instances, I believe we have an SB, which is the Select Board as Special Permit Granting Authority. So this is mostly, I don't, you know, sometimes when I see something like creative development or open space development, I ask whether or not you've had success with it. If you've had it for 35 years and it hasn't ever been used, I might suggest to you that you look at one of the models that I've used, sometimes called flexible development. But you've covered all of the, at least on paper, you've covered all of the opportunities that I would identify here, meaning single, 2-family, mixed use, multifamily, two forms of alternative development, and then lastly, something for seniors. I'm going to take it a page at a time. If you want to stop and discuss this page or ask a question, then here's your chance.
Any feedback from anyone on this? And we'll start by saying thank you very much for the explanation, particularly in number 12, senior housing facility. I think the terminology you're using is consistent with the way that it was originally intended and the way that it is being actively used in the town itself. That we do have a congregate care facility that is fairly new in town. So, and it does have multiple levels of care. So with that, Mr. Noel.
Yes, thank you. And thanks to everybody, and Attorney Bobrowski, thank you for the very nicely reorganized use table. It made me laugh when I saw it because you're exactly right. grouping all the like terms is really, really helpful. So I really like that. I also really like calling out the BA, PB, SP. Like that makes it a lot more visually useful too, and directive. I did have one question. Well, so a couple questions. Just from a layout, I mean, it looks like, right, none of the the permitted or special permit uses are changing by district, but it did look like maybe a couple columns got flipped. Because like they're going from left to right, SSR to LLI. Yeah, you'll see.
Yeah, you're right. I see on the end, I preceded LI on a couple of them.
Yeah, and B and NB got flipped, so that's just something to look out for.
Okay, I'll go back and make sure.
Yeah. Like knowing that senior housing facility is becoming a more inclusive term, we'll look to make sure that has a better definition ultimately.
Yeah, there is a long definition in the definition pages that I gave you, I think.
Yeah. Oh, maybe I missed it. Okay.
No, I didn't put it in there, but I will put it in there in the next version.
Yeah. Okay, great. So mobile home park didn't make it in. I don't know if that's that, does that belong here? Does that belong somewhere else?
Is that a total how do you treat them today?
It's in the current use table. I don't know if there's any spot that, I mean, we don't have one, or a manufactured home subdivision or grouping.
I would put it here on this page.
Yeah, okay. So, but I do generally like how I don't want to wanted to do this more efficiently than last time, so I don't want to take up more time, and so I did have one other question after saying that. Creative development, that's more speaking to a mix of artist workspace and housing, and artist businesses. I don't know how that fits with flexible, but I'd love maybe a reference to flexible development just for.
So flexible development probably lines up best with your open space development.
Okay, all right.
It can be single family units only, or sometimes it's up to maybe a threeplex, depending on the size of the town and its appetite for this kind of alternative design. But it's exactly what it says. It doesn't have to be lotted, for example. You don't have to take the land and divide it up into individual lots with 20,000 square feet. The thinking is that the market will drive the design, and to the extent that the houses are going to be desirable for development even closer on a smaller lot, that's fine, or no lot at all. In other words, the entire thing can be developed as a condominium project. Those of you who want to see an example might want to Google ConcordRiverWalk.com. It's a project that was modeled after West Coast cottage living. Think Bainbridge Island or Sausalito. Yeah. The guy bought 2 single-family homes on Main Street. Behind it was a long spaghetti-like lot going back to the Astabet River. He had to respect the river restrictions in the Wetlands Act. But behind the 2 houses on the street, which he converted into 2 duplexes, he built 9 homes basically in a semicircle with a community building in the back. So they're very close together. They're probably no more than 10 feet apart. You gotta like each other in the house, and you gotta like each other next door. But for those who self-select this kind of lifestyle, it's worked out perfectly. The houses are beautifully designed. They're energy efficient. There's a garden in the center. that everybody tends to, and there's gardens in the back for vegetables that everybody tends to. All of the access is around the perimeter of the ring of houses. There's nothing that takes you to your front door. You got to walk to your front door. But that's just that developer's choice, and it's a beautiful example of how creativity can make for a good project. Other people just shorten up the road and leave some open space where it's most important, whether it's a field or nice stretch of woods that isn't disturbed. That kind of, it's all by special permit, and those kinds of choices are made by the planning board, typically acting as SPGA, and the developer, who's after all just trying to make a buck. So
No, thank you.
another good example is Cannon Forge in Foxborough, which is a little bit more towards the number 8 with attached dwellings. I don't think there's anything bigger there than a triplex, but it's hundreds of homes up a hill basically, and there's singles next to duplexes, next to triplexes. Everything is sited so that no garage doors face the road. It's a wonderful project with just a different style of living. It's a community center style of living. There's a tennis court or 2, there's a pool, there's a community building in the center, and everybody has the right to use that.
Those are good examples, and I'd love to step through them. And I'm glad you're bringing them up, and I think it does invite future discussion. Come to the planning board and talk about I think creative and thoughtful uses of land and density and things like that. So building typologies. So thank you.
You bet.
Other thoughts, other feedback on this page? Mr. McGrail.
Thank you, Mr. Lieber, Mr. Chair. I just had a comment on this, that I think that change the name is a good idea, makes sense. I just wanted to point out to Mark, when you do the definition, our definition is now it's assisted living facility. And when that went to town meeting, it was important to the town meeting that we have a requirement that 50% of the units have to be independent living units. And that's built within the definition of assisted living facility. And that was vetted at town meeting because people wanted that mix of units within projects of this nature.
Yeah, I don't know when that was or whether that's consistent with what the town meeting would want today. My work in this area is largely driven by the fact that my folks managed to touch all types of every type of housing in the last 12 years of their life. They went from single family to to independent living, where there was community amenities but no care component, to assisted living, and then ultimately that was the end of their road. So I've seen all of these facilities in action over I think they moved out of their single family home on the Boston Marathon bombing weekend, and they managed to breakneck speed go through all of these different types of facilities. For example, there's a gentleman on Cape Cod, as he calls his operation Wise Living, and he just does independent. That's his model. And then obviously there are people who do assisted living, and I don't try to predict their economics, but one of my clients, for example, is the Essex Living Group up in Rowley, and they've got 5 or 6 facilities, and they're just straightforward, plain assisted living facilities with no internal, allocations of the independent versus assisted.
Yeah, I personally would like to see that eliminated, but I'm just pointing it out because, and actually what it says is, and it defines, assisted living facility as a residential development under Mass General Laws, Chapter 19D.
Yeah.
Then it goes on, and it says an assisted living facility may also include independent living units as defined by the Wakefield zoning bylaw, because we have a definition of that also. However, the number of independent living units shall not exceed 50% of the total number of units in the facility.
Yeah,
And so, I guess, is a point kind of order to you, Mr. Chair, where this is, and I think this is where, some of the planning board members have struggled with this, I think the charge here is a recodification of the bylaw. And, some of these things we're talking about are substantive changes that were, vigorously vetted and debated at prior town meetings. So, I don't know how a small group of people can make determinations to make changes like that. And then, not without it being a community-wide initiative. And I think that Mr. Noel and planning board member Hogan have kind of talked about this a little bit. So, when it said, well, whatever we choose, I mean, that's going to be, that's going to be an interesting process, how we're going to go about that as a town. Because there's only 10 people on this meeting.
yeah, your point's well taken. My standard definition for assisted living is a facility licensed under Chapter 19D, period.
So just a thought, but I think the idea of changing it to senior is more appropriate because the definition of assisted living facilities a little bit misleading because it's not just assisted living. It does contemplate independent units.
Thank you for your comments. I will point out that part of the charge of the bylaw review committee is to review and make recommendations to the town for updates. And that part of doing this collaboratively in conjunction with planning board and board of appeals, as well as the public, including yourself and others who are taking an active interest, is so that substantive changes as they are made will be highlighted as a part of this. And in the end, town meeting has the ability to do as it wishes with the recodification and including the ability potentially to do floor amendments and other things. While they're not encouraged, it's not prohibited by the process itself. And there will be a relatively specific and very deliberate outreach to the community at large that this is going on, and it will include some changes that are substantive. We're trying not to change the maps or other components, but the policy components are certainly affected by recodifications. Just the nature of what happens, there's quite literally terminology changing, the way things happen, and it does impact people. That's part of why this process, even at this early stage, is so public. So what you're saying is absolutely spot on, and we do intend to make sure that people have the ability to go through this process. As Mr. Bobrowski has said, oftentimes communities go through many drafts. I suspect for this exact reason, as people get more comfortable reading the drafts, when they read it, things come to light, and that's why a new draft needs to then be generated.
Okay, I think it's just the word. I think the word recodification, and I don't think it's intentional. So when I say this, I don't think it's. I think it's a little bit misleading. Recodification to most people is we're just going to reorganize the bylaw. That's the process that's happening. So the point that you make that it's going to be publicized, and there are going to be various drafts, and there are going to be. It is going to be specifically pointed out, I think is important. And I advocate for some of these changes, by the way. I think they're all good. Not all of them, but I think a lot of them are good and need to happen. So I'm all for it. But in any event, on this one page, I think there might be something else that needs to be changed on number 9, mixed use development. I think under MR1 where it says SP3, that should be PB3.
Yeah, you're probably, those SPs were in the original notes. I'll
Yes.
convert that over.
Yeah, not a big deal, Mark, but just to
Yeah.
catch that now when I saw it. That's
Yeah,
all.
no, that's a good catch.
That's all I had on this page, Mr. Chair. Thank you.
Thank you. Any other comments on this page? Would you like to go to the next page, Mark?
Sure. So these are the Dover, so-called Dover uses, most of them, or many of them. I like to put what the statute says rather than some abbreviation. The first is use of land or structures for religious purposes. The second, rather than nonprofit educational uses, use of land or structures for educational purposes on land owned or leased by the Commonwealth or any of its agencies, subdivisions, or bodies politic by a religious sect. For example, the chairman and I spoke today about the new school that you're building. This would be a Dover protected use under number 2. Third, and little known, or certainly not as well known, is child care center or school age child care program, which enjoys the same protection as a church or school. And I will come back to that series of substitutions I've made under the column entries, all to Y, because that's pretty much where the state law and the cases there undertakes you. And the number 4, 5, 6, 7, 8, and 9 are all, and 10 are all in your existing bylaw. I think you've covered most of the municipal possibilities. Governmental administration or public safety building is allowed as of right across the board. Municipal recreational use, only one BA in the first column. Waste disposal gets a couple of BAs in the last 2 columns. Utility provider or service provider, including all those listed items like offices, warehouses, garage, parking, storage of equipment. This is your DPW municipal entry. Gets a couple of special permits in the last 3 columns. So a word about municipalities. Municipalities do not enjoy a exemption from zoning unless the local legislature, town meeting, provides for it. And then if it does, it can be exempted. Typically, the exemption would be like the one for governmental administration or public safety building, Y across the board. That's a use exemption. You can also exempt these facilities from dimensional constraints that would otherwise apply. If you don't do that, then they're subject to the dimensional constraints. I once represented the Wayland the police department. The architect designed the damn building too tall, and they didn't have a dimensional exemption, so we had to apply for a variance. One of the easier nights I've ever had. Until one of the neighbors sued. Rather than defend it, we had the architect come redesign the building. So it can be something that you need to think through. I crossed off railroad station because railroads are protected under the Interstate Commerce Commission Termination Act from the end of the 1990s. The ICC was replaced with the Surface Transportation Board, and it now governs the nation's railways. And generally speaking, railroads are preempted as a matter of statute at this point. The last item is essential services, which should be in yellow. It's a new term. And I think I took from your existing use table something about, there was a list of utilities, for example, but essentially this is your monopolistic government provider, public service corporation, as it's called under the Chapter 48, Section 3. My usual approach is to put all special permits across the board. These essential services are governed by DPU or DTE. And to the extent that you play too much of a game of hardball on the special permit process, the DPU or the DTE can override the local decision. But until you get to that point, I prefer to at least have a discussion with the provider about certain conditions that the Y just isn't going to bring you. So the 6 Ys in particular, I would probably prefer from a legal perspective to put them on BA. Just to go back to number 3, you were calling your exemption, your use there, a daycare center. I know what you mean. But the statutory term is a child care center or school-age child care program.
So I have a quick question, Mr. Mullen. Welcome to being in a meeting with Mr. Bobrowski. We're gonna leverage some of your expertise here as well. For the essential services, if that's local utilities, because our local utility, I think the entire town is covered by the WMGLD as the utility itself. Are there would Verizon, Comcast, and RCN as cable providers also be considered similarly, or is this really just the electric utility? In which case, do we want to put the encumbrance on the municipal municipal department for those components? You may know more of the history of this.
So I guess it would be the electric utility, the Wakefield Municipal Gas and Light Department, and also the Wakefield DPW to the extent that they provide water and sewer. As for whether it would include cable, I don't know. I wonder if Mark has any thoughts.
Typically, they are included. Tom, welcome to the evening, and nice to see you. The only thing that wouldn't typically be included here is cell service. They tried to join the list many years ago. I remember Mark Lanza and I had the case in Franklin. They had already put the tower up, and we actually got the tower down.
Wow.
They were not protected by DPU DTE. But this is a substation for electrical. It's a Verizon substation. It's a water tank. It's all of that would fall under essential services or public service corporations, as it's called under the statute.
So it sounds
my
like
recommendation for the railroad is just to get it out of there, because the supremacy clause, if you listed everything protected by the supremacy clause, you'd have a list that goes well off the bottom of the page. Post offices, etc. Those are good examples.
So with that, is it your recommendation that we should change the essential services from the current mix to just be all to go through the zoning board of appeals, just so that way even if there's a new substation or another component, what comes to mind is the WMGLD, which is our local utility, is in the process. They're going to be building an electric utility park. So it's a battery storage system that's going to be on land. And right now, I think I'm not sure what the zoning is for that particular parcel between the two schools, but I believe that's being done by right. That would then go before the Board of Appeals. Would that be considered to be a significant increase in problems for them? Or is this something, I know that historically municipal side has not seemed to have a difficulty with the Board of Appeals. And so I just wanted to get your thoughts on that. And Mr. Mullen, if you got any thoughts, because again, you have the historical knowledge of what's been done. Mr. McGraw, you probably have been the special municipal employee for almost all of these projects where it is required.
What kind of battery storage facility is it going to be?
They're calling it an energy park.
Will it be accessory to some solar facility that's on the premises, or is it going to take energy from off-premises locations and be a large battery storage facility?
It's the latter. It's taking it from two schools, both the high school and the vocational school will be the primary feeds into the storage facility. And then it will service, it has the ability to feed those buildings as well as the rest of the town, is the intent.
So this is a really new topic. The Attorney General recently wrote Carver a letter that their very aggressive bylaw on battery storage facilities was to be considered an intrusion on the protection afforded to solar energy systems under Chapter 48, Section 3. And that Carver's regulations went too far in that they prohibited or overregulated what basically is just another extension of the solar energy facility. So we're really seeing the edge of that war starting now, because I think by 2025 we're supposed to have a certain amount of energy in storage, and we don't have the facilities to do it yet, as far as I know. This is when you get to that particular issue, the battery storage facility, this is playing out in real time right as we speak this evening. Not to mention that the whole issue of how the solar energy system exemption in Chapter 48, Section 3 plays out is a total confusion at this point. We had a case called Tracer Lane from the Supreme Judicial Court last summer, and the court looked at Waltham's regulations, which limited large-scale ground-mounted. It was actually just a road to ground scale, ground mounted. But when it looked closely at the Waltham ordinance, the only place you could do anything associated with large-scale ground-mounted was 2% of Waltham. And the court said, no matter how you slice it, that doesn't cut the cut legally under the solar energy system exemption. But what did it tell us as municipal officials? Really nothing. I mean, there's a large delta between, you can't have a town with 2% only for large scale ground mounted, to the overriding question is usually, can I have solar energy large scale ground mounted in my most elite residential district, or can I say no? We still don't have an answer to that question. And the cases are just sort of dribbling in one at a time, in which various permutations of Tracer Lane play themselves out. So the battery storage facility kind of links up with this confusion on solar energy systems, and in 5 years we may know the answers, but we definitely don't know them right now. I recall going to the Abstract Club meeting a year ago, and the people from the Tracer Lane case were there, and they talked about what they knew and what they didn't know. And I was, at that time, I had 2 towns with annual meetings that week in which I had drafted solar energy facility bylaws, and I asked them if they could help, and they said, no, good luck.
Mr. Noel.
Would solar energy battery park be a new institutional use to put in here, or does that go somewhere else?
Yeah, I just wrote a little bylaw for the town of Irving, and I think a lot of this is happening in small rural places because there's generally less opposition. But I can share that with you when we get there, and I would put it in the use table if this is something that's facing you.
It's definitely something that the town is going to be, is planning to build. We recently passed it at a recent town meeting. And again, it's part of what may make this a little bit different is that it is a municipal department that actually is going to be building and owning the park itself. So it's not a private institution. It's actually
it may already fit right under 10 then.
Yeah.
Yeah.
Yeah, I think Mark's right. I do think it fits under 10. And I just want to point out, Mark, I think this is great what you're doing with the essential services. I just had a comment. If you read on it in the definition that you provided of it,
yeah,
at the end it says specifically excluded from this definition are buildings necessary for the furnishing of adequate service by such private or public utilities for public health. I would suggest that we should take that out, because virtually everyone, my experience in doing these, virtually, when you look at definition of building in our bylaw, it's very broad. So virtually every one of these sites is going to have something that would be classified as a building.
Okay.
And to me, this doesn't get rid of the dimensional requirements, right, Mark? The dimensional
Right,
requirements.
no, it does not.
So to me, there would be no harm having a building. I think it would actually be necessary for a lot of these services, but the protection is the fact that you would need to meet the dimensional requirements in the bylaw. And then, Mr. Chair, for your comment, I think what Mark skillfully crafted this is he kind of went by what we now call a telephone exchange or public utility use, excluding any office or storage or repair. And I think the way Mark has done it this way with essential services is much better. And in that one, I would suggest that the special permit requirement should only be for the residential districts to protect them, that they have to go through a review process with the board. But I think if there's going to be a utility in a business or industrial district, or one of the limited businesses or limited industrial districts, I would respectfully say that should be a yes. That's just my opinion. That's basically what we have now.
Duly
Other-
noted.
Other input on this page? Shall we advance to the next page?
It gets easier. I don't think of you as a farming community. So the agriculture on 5 acres is well known. The statute was amended a decade or two ago to add or to qualified acres. A qualified acre is a parcel on which there are $1,000 of gross proceeds in a calendar year. And so 5 acres is sort of automatically exempt, and 2 qualified acres now are as well. The only other thing here, what's agriculture for domestic use only? Many towns have defined agriculture in this context to be the growing of crops or certain other activities, but not for example, a piggery or fur-bearing animals or other things that are going to cause a nuisance in the neighborhood in terms of smell or dust, things of that sort. And then lastly, outdoor commercial recreation. This is not an entry that you have today, but it would include things like swimming clubs, golf courses, miniature golf courses. It depends on how you would like to define it, as opposed to indoor commercial recreation, which is in D. It's D is not numbered yet, but it's halfway down the column on the first page in yellow. And I could decipher how your bylaw today treats theaters, cinema, bowling alleys. And so I kept that alive. I didn't see anything that was compatible with outdoor commercial recreation. Well, I'm looking for the entries in the columns there too, Mr. Chairman.
Any feedback, thoughts? So
This
one
could be a
question.
contentious area. So
Two quick comments on this, and am open to others as well. First is in the qualified acres, especially given the recent dramatic inflation, $1,000 per acre on sales of almost anything is very easy to achieve. You can do that from sale of plants and so forth without much effort, probably even food. 2 acres of growing is substantive in the town, but certainly there are some lots that could do that. Is there flexibility on the amount to make it, to determine what would be a qualified acre?
Well,
it
it's in
can be
the,
more.
it's in the chapter 48, section 3 language as $1,000 right now. So I think it would actually take an amendment by the legislature.
Okay, so that's a state
Otherwise,
li-
if you
state
go to
limitation.
2,000, for example, somebody's going to claim their rights under 1,000.
Thank you. And then we don't currently have any golf clubs or zip lines or anything of the sort in town as of now. But with the loss of things such as nearby mini golf and things along those lines, someone could want to do that. So having outdoor recreation may make sense. And to the recommendations for that, if there's feedback, certainly open to hearing it. Otherwise, I'm going to recommend that we defer that for right now and until we can get a little bit more information, particularly from Planning Board and Board of Appeals. We'll talk about that a little bit later in the meeting about how to potentially get some additional feedback as well.
Well,
But if
your worst nightmare here is pickleball.
If pickleball, we do have a pickleball, but that's actually on town property. So that's existing parks. So the town,
A colleague told me that there's 5 stages to pickleball. The first being absolute disgust and the last being obsession. Can anybody tell me what the middle 3 are?
They have to do with different degrees of hospitalization based on injuries that use this.
Like,
the best answer I've heard, Theo. Appreciate it.
Yeah.
Other thoughts? Anyone going to be opening a commercial pickleball facility? They'll have to compete with pickleball courts that just opened behind the Hartshorn House, which from everything that I see get quite a bit of use. So there's definitely a lot of interest in town, and those courts are quite nice. So Mark, if you're into pickleball, feel free. Right next to Lake Quannapowitt, there's 2 new pickleball courts that opened up, and they're reservable online.
You don't hear them from your house, Dan?
What was that?
You don't hear them from your house?
Only occasionally when I hear more of the home runs and cheering from
From
Veterans
softball.
Field, from softball field. I live near that area. Any other comments on this page? Otherwise, moving right along. Shall we go to the next page?
yeah, so these are things that are pretty much taken exactly as you had them. I like that the drive-in retail or service establishment is all on special permit. My usual default recommendation is that anything with a drive-through, drive-in is a special permit. In every, whether it's a dry cleaner, a pharmacy, a bank, it's a special permit. Indoor commercial recreation is just a name change, so those examples will go into the definition. I noticed that you have something for hotel. I didn't see anything for motel. They're not the same. Hotels and motels differ in that motels typically have rooms that are and you enter via an outside parking lot. Every door is its own keyed entrance into a room, whereas the hotel you enter into the main door and a lobby, and then you enter through internal locked doors. Don't know that you care. I did lump together adult entertainment establishments and provided a definition for that. It is an adult bookstore, an adult dance club, an adult motion picture theater, and all of the other ones that are listed there. So that just cleans up the use table a little bit. All of them in your old use table required a special permit, and all of them require a special permit now in the last 2 districts. Typically, I would call something like a repair shop for household appliances and equipment, general services establishment. And I would also have a personal service establishment, which would be something more like a nail salon, a barber, a hair salon. You had service establishment with retail store. I'm going to take that to mean personal service establishment. And the repair shop for household appliances and equipment should be expanded into a broader definition of general service establishment, which would include things like upholsterers, other people in that kind of line of work. Your registered marijuana dispensaries. Yeah. Are we okay? No kidding. What are you on?
Just approve what on.
Oh, okay. Thanks, Mark. Okay, they're really moving fast here in Berkeley. So let me get you to restaurant uses. So the next one of these will break out services into personal and general, and I'll give you two definitions. Just making a note. On restaurants, you had these differentiations. Restaurant, sidewalk, cafe, fast food restaurant. I would assume that drive-through restaurants are allowed with a special permit or not allowed?
They're allowed, they need a special permit, Mark, under the drive-through.
For the drive-through. Okay.
Yeah. As you had said, anything with a drive-through. So right now it needs a special permit.
Okay, so maybe I should add, something to the effect that because it is it the only other mention I see of drive-through is in D, drive-in retail store or service establishment. Why don't I just, for clarity's sake, add after fast food restaurant, drive-in restaurant or drive-through restaurant, and put the same, use the D example to put 4 no's followed by 5 BAs. So the 5th entry here will be drive-through restaurant, 4 no's, 5 BAs. Under G, automobile related uses, I prefer to recognize that these are not gasoline stations anymore where there's a lift and people are, it might be, but that would be more like a repair garage. Today, to me, a motor vehicle light service station is a convenience store, a gas station, and sometimes there's also food being sold out a window, usually like a Dunkin' Donuts attached to it. We all know these places. Is that consistent with what you think a gasoline station has evolved into?
I'm seeing a variety of head nods on the screen.
Yeah, it makes
Okay.
sense.
I'm going to add food then to the definition I offered you.
By doing this, it actually also contemplates the future possibility of service stations that may not even sell gasoline, may just service electricity and so forth as well.
I think you need to be broader than food, Mark, because those convenience stores sell everything.
Yeah, they do in fact.
Yeah.
I
We have one that actually has quite well-renowned pizza.
I'll put convenience goods and drive-ins, obviously by special permit.
Mhm.
The rest of that is just from your existing.
So without specific advertising, if you ever happen to be near exit 42, Slice is well regarded as a great pizza joint, and there's inexpensive gas right there as well.
Well, That's good news. Let's go to H. You'll see I added self-storage facility. You probably have them. It's, if you're calling them a warehouse, you're treating them generally by, you're over-parking them, for
Yeah,
sure.
it's true. So true.
So rather than have to put a footnote next to the parking requirements for a warehouse, which is typically 1 per 1,000, self-storage facility, I mean, you don't need, on an 80, 85, 90,000 square foot facility, you don't need more than 10 parking spaces. Name the last time 3 of you showed up at the same time at your self-storage facility. And then under number 10, landscaper's yard should be treated like contractor's yard. In other words, there's outdoor storage of merchandise and equipment, and they've got to have some place to go.
If the definitions of those could be added as well to the proposed definitions for self-storage facility and landscapers yards, we do have several of each within the town that may be helpful to identify what qualifies for self-storage and landscaping. And
Okay.
to your point, self-storage facilities, we have one right in downtown. It's very small, and I don't know how much, if any, dedicated parking it has, but you're right, there's very little activity there for the size of the facility itself.
Yeah, and if you're going forward under wholesale, or more importantly, warehouse establishment, there's, now you need a variance for the parking. And that you can't get there from here.
Any feedback from the community for the items for self-storage facility? Otherwise, again, we'll defer that. So, Mr. McGrail.
Just quick, Mr. Chair, you're spot on, that we need a definition, and Mark is spot on. I've dealt with at least 3 of these, and he's so right that the parking calculations are absurd. They make no sense whatsoever. So this is a great addition and change.
Any recommendations as to what the components should be? Yeses, no, Board of Appeals requiring special permits.
You might just treat it like a warehouse in the line above. I mean, a warehouse has much more drastic land use impacts than a self-storage facility.
So my recommendation is that, again, we defer that to a smaller group to come up with an initial proposal. We'll come back to the full committee for further discussion at that point.
I suppose I should point out that a warehouse establishment would allow a logistics facility, or would even allow a fulfillment facility as of right. I don't know that your prospects of getting one of these is any good, but there are certainly people out there looking for locations close to Boston where they can build 400,000 square foot warehouses. And that, to have it as of right in the last 2 columns there is, I just came from a meeting over in Berkeley Town Hall where they are looking at 380,000 square feet and 2 separate warehouses. And it's a big impact, noise and traffic in particular. But if you're thinking in the last 2 columns of number 6 that this is more of a standard traditional warehouse, then it's not as bad. But most of these are now being built spec. The tenant is unknown, and you have to sort of draft conditions in order to make sure that you protect yourself. You're going to be subjecting them only to site plan review with the 2 Ys that you have there.
So we'll defer that to a different group for an initial recommendation. We'll come back with that.
Okay.
So move on.
Yes. So family daycare home, you have family daycare home, that's fine, but there's 2 varieties. A small is up to 6 children, resident participants included. A large is up to 10 children, resident participants included. The next stage, oddly enough, is a childcare facility, which is a yes across the board. But these are things that spring up next to other people in residential neighborhoods, licensed by the state, of course. My default position has always been that the family daycare home, small, subject to state licensing procedures, is a yes. But if you're going to stick 10 kids next to me every day, I probably want to go to a special permit hearing for a large one. Just calling it out to your attention. You could just repeat number 6 in number 7, or I can just put large and small in number 6.
Feedback from anyone in the meeting? Mr. McGrail. You're on mute.
I just had a real quick feedback on the table. I talked to Jim Hogan on the planning board about this, that we might want to eliminate this MR1 because we don't have that in our town. Just to point that out for you to, kind of maybe put for a later discussion point. But our zoning map has there is no MR1 district.
Thank
So
you.
just doesn't exist.
The case law on accessory uses has changed pretty dramatically in the last couple of years. Remember, everything in a use table is prohibited unless it's specifically allowed. I had a case in Charlton. The question was whether or not manufacturing and processing of marijuana products were accessory uses to a 1 million square foot grow facility. Nowhere in the bylaw did it say that. Judge Foster in the land court ruled, and the appeals court upheld him, that accessory uses are different because you can't possibly think of everything. So if there's something in here that's accessory that isn't listed in 1 through 9, but it's subordinate and incidental and customary to a residential use, for example, or for that matter, to a business or industrial use, it would be allowed under the recent holdings of the appeals court. And I think that's actually a pretty good approach, because you really can't think of everything in the table. So if you'll go back to when you see section 3 in the recodified bylaw, it will say it's what's in section I, accessory uses, plus anything that's customary, incidental, and subordinate.
Feedback on the accessory uses? Including as to whether there should be a differentiation between small and large family daycare homes.
And in number 8 and number 9, the craze these days has been to go to accessory dwelling units as defined by Governor Baker. So we'll be talking about that in the next meeting. I'll look at your accessory apartment regulations for these districts, and then I'll show you a typical ADU bylaw that takes the benefit of the governor's housing legislation from a couple of years ago.
I just
Mr.
think
McGrail, go ahead.
I just was going to say, I think 8 and 9 could be consolidated into one line because it's just repetitive.
Except that they're not the same if you look at the uses in the first 2 boxes there. So I guess you can have accessory apartments.
You can have them in both of those districts. They're just stated different places of in the bylaw.
Yeah, I'll fix it. Yeah, but that's what it says now.
It's awkward, Mark, but they both require a Board of Appeals special permit. So I see why you did it, because it is awkward the way it is in the bylaw.
Yeah. All right, I don't, what time is it here? My planning board clerk is lurking around here. I'm gonna just excuse myself for a minute and find out what's going on. Hang on. Going on.
And for those of us, I think everyone here has been to town meetings, many town meetings. We get to be at a town meeting in another town, just what we all wanted.
No, we don't.
This, I know Attorney Mullen likes town meetings because he attends lots of town meetings, but
He's probably at that same town meeting.
All right, they're on the library. I'm told it's gonna be quick, and I'm next, and they're not acting very patient. I think everybody wants to go home and watch the second game of the NHL Stanley Cup.
and I believe that brings us to the end of the table itself.
Yeah.
Okay. Dan, I'll catch up with you as to anything else that's discussed, and I thank you all, and I beg your forbearance for having this town meeting tonight, but your turn will come and we'll even it up.
Excellent.
Thank you.
Thank you for joining us. We do appreciate it.
Great.
So with that, one of as Attorney Bobrowski mentioned earlier, he and I did have a discussion earlier today, and amongst the items on that we discussed was how to improve some of the feedback to him for certain items, such as the tables, the table entries that were blank in this particular meeting. So amongst the suggestions that he had was to create effectively a subcommittee to help with the first draft. And the primary purpose would be to really help with the first draft, specifically by going over some of the elements of the language as we've now gone through 3 of the 4 preliminary meetings, and to then guide him with that particular language componentry. Anything resulting from that will come back to this greater board for further discussion. But the idea is just to provide him with some direct advice on a smaller scale, which should be realistically a little bit more informal, probably faster, less coordination. The idea was to either do it as three members or 5. The idea for the 3-member board would probably be the chair or designee of this board, the planning board, and board of appeals. And then the secondary option, where we do have 2 members who have dual roles, would be to have potentially 2 members of board of appeals, possibly the chair, and perhaps Mr. Pride, if you're willing to do it, and then 2 members from the planning board, possibly Mr. York and Mr. Noel, and the idea being that would provide expertise in the land use and still be a smaller body. The meetings would still be public in the sense that everything would be posted for anyone who wants to attend, but it doesn't require as much coordination, and it would just be an advisory role as opposed to a decision role. So all major decisions would absolutely come back to the main body, and it would not negate any opportunities for input by anyone. The idea really is just for some of these smaller items to at least have a starting point by some expertise and make the process a little bit smoother. So that was part of what we wanted to discuss. Didn't want to make any sort of decisions without getting the input and getting the idea of feedback from those who are attending the meeting. So with that, thoughts from people on this? And I don't want to automatically volunteer other people's time without their approval either.
Yeah, Dan, I saw that email earlier today. I haven't heard back from Dave. He hasn't really responded yet, so I don't know what his position is on that. If it's 5-member, I can step in under him. I'd rather him take lead on that, since he's been on the board for, I don't know, 10, 15 years now, so he knows a lot more than I do. That's why he's chair. So I'll let him respond to that. And if it's a 5-member, yeah, I'll throw my hat in the ring. It's fine. I'm fine with give me more of my time, I guess.
So this would be one subcommittee to do all like the things that we've deferred tonight.
Correct.
So at each point, this subcommittee would then meet separately to nosh on stuff and then come back.
Correct. The idea is that the subcommittee would really help to provide some of the input and at least identify, okay, this is an issue that is specific in town, and there I can very easily see where the subcommittee says it's not appropriate to make a decision. An example would be, are we a special permit town, or are we a
Findings
or,
too.
or a decision along those lines, whether it's special permit or if we need variance, those types of decisions where we say, let's leave that to the larger committee to make a decision. But I think for some of the smaller items, to at least have a starting point will make the overall process have a smoother process, a smoother time, and will be able to meet more often than the full committee itself. Because to navigate and manage 5 people's schedules is a lot easier than to navigate approximately 15 at the moment. So that's part of what's driving it. And whether it should be 3 members or 5 members, certainly want to get thoughts on as well. But it definitely needs planning board involvement, definitely needs Board of Appeals involvement, just because the expertise on the land use is within those bodies. In addition to that, I also recommended that Aaron Kokinda join the committee. Realistically, I don't see there being any votes of substance in the committee itself, but to join and advise the that same board, as she has access to the professional staff within town hall, and to represent those interests, to make sure there isn't something that those of us on the volunteer side are overlooking or are unaware of, because there are things that happen that she will be aware of that we will not, most likely. So the idea is to represent the main interests, and again, everything comes back here, and that way people can, anyone who wants to observe those meetings is welcome to, but a lot of the process can go a little bit faster, a little bit smoother, without any final decisions being made. The final decisions are always made by town meeting itself, and there will certainly be a very publicized process before that, so that we can get additional feedback. To Mr. McGrail's comments earlier, we want to make sure that people have the opportunity to get feedback and give feedback. We've seen that there have been people who've joined the meetings. Some will say something at a meeting, some won't. But the more input we have, the better I think that the outcome will be, as this recodification is really quite significant for our town. It's going to help define the bylaws for at least a generation, possibly 2 or more, because these are setting up the land uses, what people can do, and it takes time for these to have substantive change. A lot of these uses have never been fully codified in an organized fashion. So I don't want to anyone to think that input is not welcome or encouraged. Anyone is welcome to give it. By the same token, want to make this process run as smoothly as possible so that we can get through some of the components here where we're seeing it's just a lack of familiarity with the nuances of the town itself. So thoughts? And this is open for anyone on any of the boards, anyone who's in the meetings, welcome to contribute thoughts to this. Mr. McGrail.
And I was just gonna ask you, so during the subcommittee meetings, you would be open to taking comment in your discussions?
We would be open taking comment to the extent, honestly, that Mr. Bobrowski wanted to take comment, because this is really an advisory role to him in his ability to then provide feedback to this larger group, because his contract is with town itself.
I guess my only thought on it is I think you mentioned that this group that you're talking about would make some substantive decisions on, for example, a special permit versus a finding. And my only concern to that is you're narrowing the group that's going to be making some real substantive decisions. And I think it will be critical that group would have input from public as they're discussing what those decisions are going to make and what the repercussions or outcomes might be.
Input is always welcome. The idea is that anything that looks or appears to be a significant decision, they won't be decisions themselves. They're just recommendations. And I want to make that distinction really clear. As a recommendation, it will be it'll be elements to go into a draft by Attorney Bobrowski to come back to this full committee. So the idea really is just that he has a better starting point of, okay, what is the definition of and the differentiation between the small and large daycare? Does there seem to be a component? And the answer may come back to, we don't have enough familiarity with it. Let's start with the basis and highlight it so that it can be a part of a discussion with a larger group. That's really where I see the piece, as opposed to, okay, this should be a finding town versus this should be a special permit town. It's something that is known to be of great significance, I fully expect will come back as a, not necessarily even a strong recommendation. It may just be, this is what the history has been. And, the committee, the subcommittee may say the recommendation is that we consider keeping it, but the decision as to what the direction is fully for Attorney Bobrowski rests with this larger group. And that's intentional, so that there's additional feedback always welcome before anything gets ready to go before town meeting, well before town meeting, because there's a process before that as well. So the short answer is feedback will be welcome, but a lot of this is going to be driven by Attorney Bobrowski himself, so that he can get the feedback that he needs quickly. Other thoughts? And whether it should be 3 members, five members, because really it's just so that he has additional people to get feedback from, and to get a better perspective of the town quickly.
So the workflow would be, he would present like he did tonight, and then those items that were deferred would go back to the subcommittee. It sounds like the subcommittee would be able to meet a number of times leading up to September, when the next meeting with him is. But by that point, they would be able to come back with some response to the items that were deferred.
Correct. The way you described it is what is the recommendation. And the idea is that subcommittee would likely meet quite a few times over the summer. It would be by Zoom, so whether those meetings took place in a basement, which is where my home office is, whether it's a living room, a home office, a backyard, by a pool, Cape Cod, wherever a person happens to be, London or Florida, if wherever people are escaping, New Hampshire, Maine, all fantastic places to spend summer. That's all welcome.
I don't,
But-
sorry,
ahead.
I didn't mean to interrupt you.
Go ahead.
I was just gonna say, I don't have an opinion on the 3 versus 5, but I think this sounds like a really efficient process that you're proposing. It's a way to make use of this time, but it's a long time between meetings. So it seems like we'd be able to make some progress, and I like the proposed structure you've laid out.
So legal question for Tom. Any issues with this as being a subcommittee? Well, I'm assuming that it would then need to be posted and so forth. As long as there's minutes and so forth, then it should not be a problem with open meeting law.
Yeah, so as I understand it, all the members of the subcommittee would be members of the bylaws committee itself, right?
Probably not. It would probably consist of members who are members of the planning board and the Board of Appeals, but not a quorum of any board.
Okay, so less than a quorum of any board that contributes members to it. Appointed by whom?
The idea realistically would be appointed by this committee. So as chair, I would do the appointment for this committee, and the tenet of it would operate to advise Attorney Bobrowski. So the piece that I'm not sure of is if Attorney Bobrowski would be empowered under his contract to, appoint it himself, then it would be merely advisory to him and not necessarily be a public body. I don't think that there's a problem with having things posted either.
Yeah, well, since it's being appointed by this group, which is a public body, it would itself become a public body, even if we say that its purpose is to advise an individual. So we'd have to treat it as subject to the open meeting law. But since you're content to do that, I don't see a problem.
Excellent. I think that it's in the public interest that as much of the process be visible as possible. Other thoughts?
So I would vote for 5. It doesn't sound like we ever need to have a quorum, since we're not, I mean, you wouldn't want to do it without 3, but
3 would be the quorum. So 3 of 5 would be needed to have a meeting, but I can't see it being very useful with less than 3, but having 5 would allow for different things to happen, and I think still provide sufficient feedback.
right.
Dan, is this still part of the budget? Is that? Yeah. How
The
does that
time,
work?
great question. The time for this would be, some of it would be included in the standard contract under the under the initial part of the recodification. Some of it is likely to be in the hourly piece, and all of that is still covered by the budget that has been allocated by town meeting.
Yeah.
So fortunately, there's not a budgetary problem with this. Mr. McRail.
Yeah, I just had a question for Tom. I mean, I think it's a good idea. I'm just wondering as I'm pondering this, thinking, and I don't know the answer, but the question is, Tom, does the bylaw committee have the authority, as they've been composed, to appoint another committee to somewhat take charge of things that they've been appointed to do? I suppose they probably would, where it's only advisory. Does that make sense?
Oh, yeah, I don't have a problem with that because of the advisory.
The
nature.
advisory part of it.
Yeah.
Yeah, I agree. Okay, I was just kind of pondering that, just to make sure that nobody steps into a problem where they don't want to, but that makes sense to me. And I think it's a good idea.
So with that, just so there's a formalized acceptance of this, I think it makes sense to have a vote just to authorize the creation of a subcommittee. And based upon the comments here, I think 5 it probably makes sense. So do the authorization to create a subcommittee of up to 5 members, consisting of at least 1 member of the planning board as the chair or their designee, 1 member of the zoning board of appeals as the chair of their designee, at least 1 member of the bylaw review as a chair designee, and 2 other members as determined by the chair. And that will allow for the flexibility if people have to rotate in and out of the committee itself. So the motion I'm making is to create a subcommittee of 5 as designated, with 3 members being specific as the chairs of the planning board, board of appeals, bylaw review, and 2 additional members. Is there a second?
I'll second that.
Joe seconds, so I've made the motion. Joe seconds the motion. Further discussion? Okay, with that, we'll take a roll call vote on that. Eric? Thumbs up, that'll be in approval. Joe,
Yes.
Tim,
Yes.
Kevin,
Yes.
Catherine,
Yes.
and I vote yes. So with that, we've got unanimous vote on the creation of a subcommittee. Excellent. So I will be in touch with you, Theo. I'll also be in touch with Dave. He just got nominated to committee that he wasn't a part of. Joe, if you want to give him the heads up on that, you're welcome to do so. He has yet more work to do. Or of course, it does allow for his designee, and how he chooses to do that is really up to the Board of Appeals. The idea really is the core purpose is to get land use expertise together to help with this advisory nature. So the next item on the agenda itself, some upcoming dates. We have in the third Monday of June, continuing with 2023 being the weirdest calendar for doing meetings on the 1st and 3rd of every month. June had the third Monday of the month happens to be Juneteenth. So happy Juneteenth, everybody, in 2 weeks. Fantastic celebration. Highly recommend that you attend. I think there's a flag raising that's going to happen for that. It's usually a great celebration. It's great, a really meaningful holiday. You didn't celebrate it last year, highly recommend learn about it and learn why we do it. A lot of components to it that will probably remind you in some ways of other celebratory celebrations of freedom. In July, the first Monday would be the day before the Independence Day holiday, so July 3rd. That doesn't quite seem appropriate to have a public meeting on that evening. Most people are preparing for the 4th of July. That brings us to the end of July and into August, which tend to be a very quiet time for large committee meetings historically in the town, and I recommend that we continue that. People tend to take vacations, be in different areas, which brings us to September. Monday, September 4th is another holiday, and that would be Labor Day. So that brings us to the next meeting be Monday, September 18th. And that would be the meeting to go over the last component tree, the residential pieces of the first 4 meetings with Attorney Bobrowski. And I will work with the subcommittee as it's appointed to have earlier dates as well. If there's a desire to go over the non-zoning pieces in July or August, we can certainly have a meeting to do that. I would humbly request that we push off the zoning until that September meeting, just so that we don't have to have the appearance that we're trying to hide anything over the summer as to what's happening with it at a large scale. But by having the subcommittee meet, I don't think that anything's going to be hidden, because it's not going to be presented until September to this board, and it's just a recommendation. But if there's a desire to meet in July or August to continue with the other recodification, we can certainly do that. Otherwise, that will pick up realistically later in the year, sometime in the 4th quarter. We've gone through over half of the other bylaws. And I would like to congratulate the committee on having unanimous passage of the 4 articles that we did sponsor, and also to the planning board on unanimous passage of the bylaw on street renaming, and that went over quite well. Bill did a fantastic job of presenting it, and there was no opposition to it at town meeting.
Thank you, Dan.
Any thoughts? Desires to have a meeting in July or August?
I mean, I can do one in August, so that'd be, it's up to anyone else, doesn't. Yay or nay, doesn't really matter to me.
I'm hearing a lot of silence from the other members, which is fine and expected. So my suggestion is that we hold off. If there's anything that comes up, we can certainly schedule a meeting between now and August. So if you hear of anything that would necessitate a change, sometimes some of the issues that I have heard of and things just to throw out for things to be aware of is as we go into the summer months, noise bylaws have been discussed in the past. The idea of coming up with limitations on noise, it typically affects it affects motor vehicles more than anything else typically, and people doing that using large or loud motor vehicles in residential neighborhoods. That's something that tends to come up a lot in the summer. We also see it on the lake with remote control boats and things along those lines. They can have a large whine. The other item that just want to throw out for people to consider is, and the planning board members may want to consider this as well. The prior bylaw review committee had proposed a vacant building bylaw, the vacant storefront bylaw, and that's something that we may want to review and discuss. The idea being that when there are vacant storefronts, the property owners have the ability to contribute to the town by having those vacant storefronts used in various ways. At a minimum, it encourages the entry by public safety and so forth on a fairly regular basis to make sure that things are happening. It encourages use of vacant storefronts. As we all know, there are some storefronts that have been vacant for years, and it would provide for hopefully either beautification or uses. It's not really designed as a way to get taxes, although for those who are not compliant, there is a penalty portion or an alternate equivalent tax portion for those who don't want to participate. So it doesn't negate anyone of their right to have a property effectively sit idle. So it's something that I just want to present. We may want to take that up for a future town meeting. The language is available, and we can certainly review that if there's a desire. We can have that discussion in more depth at another meeting. Any other thoughts? Otherwise, with that, I think we can take a motion to adjourn. And I think Catherine, I saw you moving. Wasn't sure if you were going to make that motion. Brian?
And I have one comment.
Sure.
I just want to remind you, if I could, that at the last meeting, Mark had presented sections 1 and 10, and he only had produced them the night of the meeting. So we had discussed at that meeting, and it was planning board member Hogan and myself had comments on those sections, and it was stated that we would have an opportunity to present those comments at some point with Mark. I just wanted to remind you on that. Because
absolutely, and all comments that have been received have been sent to him, and so he's going to be able to assemble his thoughts on it. And
do you want me to put my thoughts in writing on those, Dan? Would that be helpful?
Anything you can put in writing is absolutely helpful.
Okay, I'll do that. It would save some time. I'll send that to you.
Certainly.
Thank you very much. Appreciate it.
So with that, Catherine, was that a motion that I thought I heard?
I'm happy to make the motion.
Okay, so Catherine has made a motion to adjourn. Is there a second?
Second.
Seconded by Kevin. Kevin, you want to get out of here as fast as possible. Can see that. Any discussion on the motion to adjourn? Eric, any thoughts? Not sure if you don't have a microphone. Okay. With that, we will take our final vote of the evening. Eric, on the motion to adjourn. Thumbs up. That will be deemed in the affirmative. Joe?
Yes.
Tim?
Yes.
Kevin?
Yes.
Catherine?
Yes.
and I'll vote in the affirmative as well. So with that motion the motion to adjourn is accepted, 8:37, meeting is adjourned. Thank you everyone for joining, greatly appreciated. We'll see you all on Monday, September 18th. Please have a fantastic summer. Tom, thank you very much for being able to join us and for being able to lend your expertise. As always, greatly appreciated. Have a
Thanks,
great
Dan.
summer,
Good night.
everyone.
Thank you.
Good.